With dog attack cases, the first real issue the injured person faces is whether there is going to be someone on the other side that has money to, pay the compensation for the damages. I argued that strengthens the position that clearly my client isn't meant to be an owner under the Act. If she can't even sue the actual owners, under the Occupier's Liability Act. These two cases now have basically made the actual owners of dogs immune from liability in situations where their dog attacks somebody and the person that was attacked is the only one in the area with the dog, which, with all due respect, is ridiculous.
One Great Case, a podcast about law to learn more about people. I'm your host, Areta Lloyd. I'm joined today by Shane Katz, a personal injury lawyer in Toronto, Canada. Shane was recognized by Best Lawyers in 2026. Today, we're discussing the definition of a dog owner that many people may find surprising and may not know about. The claim arose after a dog walker was severely bitten by a dog she was picking up from the owner's house. Now, Shane, let me just get this out of the way. Bad joke, but do your partners tease you that with your last name pronounced Katz, you represented a party in a dog case?
I know that is definitely something that's come to mind during the course of the case, for sure.
No, seriously, this is actually quite a serious case. And could you just tell us what happened?
Yeah, my client was employed as a dog walker and by a dog walking company. And there was a couple that owned two dogs and they hired the dog walking company. And my client was assigned to these dogs. And my client developed a relationship with the family and was walking the dogs regularly. The family gave her a key to their home. And at some point, their big dog had to have surgery and had to have all of its nails removed. And so there was a period of time where that dog couldn't be walked. And the owners told my client that, just to come to the house and play with the dog a little and maybe let it out in the yard to go to the washroom. And so that was done a few times. And instructions were given to my client by the owners that if it was muddy outside and wet, that there were booties in the house that she had to put on to protect the paws of the dog. And on the day of the incident, it was muddy and wet outside. And for the first time, my client was going to put these booties on. And as she attempted to put the first one on, the dog just went crazy and viciously attacked her. And that's pretty much what the case is about.
What happened? What were her injuries?
I guess I have to stay within whatever's been revealed through the decisions of the court and in the pleadings, but she suffered very severe injuries to her, to multiple areas of her body.
Okay.
Yeah.
And so was this your first dog liability case?
No, I mean, for a personal injury lawyer, dog liability cases, are usually ones that are taken on. Personal injury lawyers work on a contingency fee basis where they only get paid if they get the client money. So for dog attack cases, usually a personal injury lawyer is only taking cases where the person has been very severely injured, and it makes sense to wait for payment after several years.
Mm-hmm. So when we talked about this before, it seemed like you knew this would be an uphill battle. And tell me about the legal grounds, as it were. I mean, what did you learn when you filed the claim? And given that, what was your strategy?
So with dog attack cases, the first real issue the injured person faces is whether there is going to be someone on the other side that has money to pay the compensation for the damages. And so the personal injury lawyer is really looking to see if there is insurance that will cover the dog owner. Because if there isn't insurance, the injured person is likely just chasing paper, right? Potentially getting a judgment that is worth the paper it's written on. So, obviously the defendants here owned a home, so I was fairly confident that they would have insurance that would respond to the claim. And, insurance companies have lawyers that are very experienced, are very intelligent, know the defenses, that need to be brought forward. Um, and in this case, um, there were similarities to a precedent case by the Court of Appeal where they found somebody who didn't own the dog to be an owner, and therefore, under the Dog Owners Liability Act, the owner that the court made into an owner was not allowed to sue another owner for damages under the Dog Owners Liability Act. And you want to proceed under the Dog Owners Liability Act because it creates strict liability. And all the injured person has to do is prove the attack and the damages flowing from it. And then it's up to the dog owner to um, prove any contributory negligence to reduce the damages. Also, to sue in just regular negligence or occupier's liability, there really has to be evidence of the owners being aware that the dog could, has the ability to harm people, has shown that history, which there wasn't in this case at all, especially given my client was a regular dog walker of the dog and wouldn't have walked the dog or continued to walk the dog if it was showing any signs of aggression. Um, Anyways, the precedent case, I believe it's called Wilkin Arbor, involved a boyfriend and girlfriend, and the girlfriend was staying over at the boyfriend's house, and the boyfriend owned a dog. And one morning, the girlfriend asked if she could walk the dog, and she took it for a walk. And while out on the walk, they had a spill and fell. And while she went to help the dog attacked her, and she sued her boyfriend under the Dog Owners Liability Act as the owner and strictly liable for her damages. And the Court of Appeal, the judge at first instance in that case, uh, was faced with a defense by the owner that she was also an owner. And the judge at first instance basically said that's ridiculous and dismissed it. But it went to the Court of Appeal where they went into this whole analysis of, who had possession and was in the best position to prevent the attack at the time the attack occurred. And so therefore found that she was and was the owner at the time of the attack and couldn't sue her boyfriend. I felt that in our case, the fact that my client was in the actual home of the dog when the attack occurred, and the fact that she was doing things with the dog that the actual owners were asking her to do and required her to do. I thought that those were two key differences that would take this case out of that precedent. I thought it was bad law and was hoping the court would agree.
Right. And actually in that Wilkin and Boer case, if I recall, the girlfriend did go after the dog, fell into a culvert or something like that, and there was a lot of emphasis placed in the decision about, well, she didn't have to go down there, she didn't have to go chase the dog.
Right,
It's like she was the author of her own misfortune.
right,
But you're right, in this case, for health reasons, the dog could not go out without the booties on.
right. Well, it's there's even within the Dog Owners Liability Act, there's even a provision where the injured person cannot sue under the Occupiers Liability Act if the attack occurs in the dog's home. And at the Court of Appeal, I argued that strengthens the position that clearly my client isn't meant to be an owner under the act if she can't even sue the actual owners, under the Occupiers Liability Act. Um, I recall during argument that one of the Court of Appeal judges actually disagreed and felt it was the other way, but I didn't quite follow that rationale, with all respect to the court.
Mhm. So the insurer brought up that this Wilk and Arbor case, and that was their defense. Um, During the lower court hearing, you distinguished it. Did you feel like you had the judge on your side? What was that day
It,
like?
yeah, I recall the summary judgment motion. So the defendant owners brought a motion to have the case dismissed, claiming that she was an owner and couldn't sue under the Dog Owners Liability Act. And I recall the judge seemed to be giving me the impression that she saw things the way I was seeing it. And I was giving her hypotheticals, um, that made the application of the way the law was being interpreted, seem very silly. You know, the the one that I used in both levels of court was the one where, you know, I own a dog, I'm working late, and I call my neighbor and ask them if their son can go over to my house and put my dog outside and feed it, and I'll give their son $20 or some kind of compensation. And then while he's over, my dog attacks him. Essentially, based on the court's decision in Wilkin Arbor, now this case, um, the boy would not be able to sue me as the dog owner under the Dog Owners Liability Act, and I thought that was a pretty good, um, similar situation. Although the Court of Appeal didn't seem to think that my examples were similar, although that seemed close, pretty close. Um, and so I felt the summary judgment motion was seeing the case my way. And then when the decision came out, um, and the way it was written, she just felt she was compelled to apply the law in Wilkin Arbor because it was a Court of Appeal case, even though I felt the facts were sufficiently different.
How did your client feel about that?
Yeah, she was shocked. She was very surprised. You have to always prepare your clients for losses and explain to them the risks. So, she was aware that the defendants could succeed. Um, but still, the fact that the court found her to be an owner was very surprising. The grounds of appeal were that basically the judge, at first instance, made an error that the Court of Appeal could set aside, in finding my client to be an owner. And it was a three-judge panel, and the emphasis was that this case was sufficiently factually different from Wilkin Arbor that it didn't need to be applied and followed in this case, and shouldn't be, given the ridiculousness it creates in its application, and how it will affect everybody in terms of how they deal with people's dogs. But the court seemed to think that it was the exact same situation as Wilkin Arbor. And yeah.
It's interesting because they at the end the court said, "Oh, but we're not foreclosing any avenues." And it's the same thing in Wilkin Arbor, where the court again said, "Well, there could be situations where this doesn't apply." But I get the sense from you that what these decisions are doing is closing off any sort of reasonable situation, and that dog actual owners are therefore going to hardly ever be liable.
Yeah, these two cases now have basically, I believe, made the actual owners of dogs, they're immune from liability in situations where they're not, where their dog attacks somebody, and the person that was attacked is the only one in the area with the dog, which with all due respect, is ridiculous, because the Dog Owners Liability Act is a strict liability act. the whole point of it being strict liability is because animals are unpredictable, and circumstances should play into contributory negligence, but to allow owners to be absolved of any liability simply because they weren't there, um, is strange. I don't think that the act was created with that intention in mind. In fact, I think the act was created with a definition of owner to address situations where nobody claimed to own the dog. It was definitely not meant to be applied in cases where there was no contentious issue about who was the actual owner.
Tell us about the history of this act. And you think you've read the Hansards, so
Right.
you're familiar with all that.
Yeah, if you read the Hansard, there was an issue of dogs roaming and causing issues, and of the owners not being held accountable because they just denied being the owners of the dog. And so this definition of owner was meant to hold the actual owners accountable when their dog causes harm, not to just create new classes of owner when the actual owner exists and it's not an issue. Um, so very strange.
So we think the statute's unfair. The court didn't close off the definition, but it does not sound like there are a lot of um, scenarios that would be successful. Um, like it just doesn't sound that the way it's being interpreted, like it's still going to close off avenues for people for
Absolutely.
grievances. So, what does one do at this point?
I think an appeal could be made to the Ontario government to change the law. That's really the only way to go, and just straighten out this mess that's been created that is allowing actual owners to be immune from strict liability, if their dog causes harm in certain situations. I think that's the only way now. I mean, the court left open other, similar situations, but again, with these two cases, I don't see how a person injured when they're alone with a dog can ever sue the actual owner under the Dog Owners Liability Act. Um,
Is there an organization or a group of non-owners or dog walking companies that are interested in bringing this to light? Will you be taking more cases?
so, usually my dog attack cases, 99% of the time, the owners in the area, right? So it's not very common to have somebody alone with somebody else's dog and get very severely attacked. Uh, but yeah, I mean, if I'm called by somebody who is, similar circumstances as this client, I wouldn't be able to take the case. At least I wouldn't be able to take it on contingency fee. The client would have to pay hourly, but I don't know if that makes sense financially, given the state of the law.
Mhm, mhm. So, what do you think? Um, I mean, obviously, there's a loss here for you, and and maybe you're more used to working in this riskier way as a lawyer.
Mhm.
What compels you to take more difficult cases?
Well, the benefit of personal injury law, is that you really feel like you're helping people in very difficult circumstances, um, and that gives you some purpose, gives you more drive and about what you're doing. And difficult cases are, they have to be strongly considered given the contingency fee arrangement that usually applies to these types of cases. Um, but if you have a good relationship with the client, you really want to help them, then you'll take on that challenge. It's rewarding.
Right. I was going to say, it sounds like satisfying work,
Right.
although it's never easy to lose.
No, no, definitely not.
Well, I guess the bottom line is if, unless you're in a unique scenario with a dog alone, you're an owner and owner beware.
That's right. The moment let's assume that this wouldn't apply to minors. Maybe that's a different scenario. But if you are 18 or older in Ontario and you're alone with somebody's dog and the dog attacks you, you can't sue the actual owner for the damages the dog caused. But even more alarming that these cases have created is that you actually become an owner and are therefore subject to being sued for the damage caused by the dog. So, you again, dog walkers are really at risk here. Um, but even if you're just a friend taking somebody else's dog for a walk and that dog attacks somebody, you can be sued under the Dog Owners Liability Act based on these cases. And I don't think the public is really aware of that.
Yeah,
And
I wasn't.
no, and most of the impression I've received from members of the public is shock, surprise at the way the Court of Appeal decided the case. So you would hope dog walkers have proper insurance for you know as an owner, because that's technically what the law is right now.
Right. Wow. Well, thank you so much for being my guest. It was fun speaking with you. I'm sorry that your client didn't get the decision that it sounds like she should have gotten. And it'll be interesting to see what happens because, as you say, it creates an absurd situation.
Absolutely. Well, it was my pleasure being a guest. Thank you for having me.
All right, folks, if you enjoyed this podcast, like, share, download, do all the things. Thank you. Until next time.